Cancellation of removal is one of the few defenses that a person has in immigration court. And if successful, the person walks out of the immigration court a permanent resident. (42A) is for lawful permanent residents who already have green cards, and they have to have 5 years of permanent resident status and 7 years total in the U.S. It's a very generous provision of the immigration law, and they forgive many issues that would normally result in somebody's removal because the person has been a permanent resident for so long. And I'm talking about extreme generosity in the law. One example is I had a client who had been convicted of smuggling a lot of drugs from Mexico, and he was a permanent resident. And he was in jail when I met him, and one thing led to another, and it became apparent that notwithstanding the crime he committed, that the U.S. government was going to thank him by helping out with the 42A application and stating what great help he had been to the U.S. government. He was allowed to remain in the United States. Now, 42B is much more complicated. First of all, it's for non-permanent residents. Secondly, they had to have 10 years of continuous physical presence in the United States. Plus, they have to be of good moral character, and they have to have a qualifying relative. And the standards are to qualify for 42B, it must be that the qualifying relative would experience exceptional and unusual hardship if the person were to be deported. Now, most immigration judges in their entire career probably only see 42B cases. 42A cases are so rare that there are many judges who've never even done one. But 42B is very common, and since the standard is extreme and unusual hardship, it's very difficult to put these cases together, and you have to be very creative when you put the cases together to be able to argue about good moral character. This part of the statute is so strictly enforced that if you have a DWI that happened 25 years ago, you will be denied 42B protection. You have to have a spotless criminal record to qualify for 42B. And that all is related to the requirement for good moral character. There's no real definition of good moral character other than the absence of bad things like crimes or huge judgments for fraud or something like that. But 42B cancellation is very rarely granted, but it takes it just takes a ton of work to make the case. But they do get granted. You just have to have a lot of hardship for the qualifying relative that you can document. Because if you can't document the hardship, it won't be considered. The successful 42B cancellation cases usually have multiple relatives in the U.S. And usually one of the best ways to win the case is if the person is absolutely necessary here to take care of a U.S. citizen or permanent resident relative who has a very serious medical condition. And so in that kind of case where there's like relatives that are sick and there's nobody else to help take care of them and they don't have enough money to take care of them, and if the person in removal proceedings leaves the United States, there'll be nobody to take care of the needs of the family, and there's not enough money to hire private people. This is the beginning of a case for 42B. The other thing about 42B cases is you want to get as much evidence that you can of good moral character, good things the person has done in the community where they live. That's very important. It's a scale that's already weighted against the applicant, but it can be overcome by more and more evidence of the hardship to the U.S. citizen and evidence of how allowing the person to remain in the U.S. they would be able to take care of their ailing relative who otherwise would have no medical care. First of all, medical documentation. If the hardship is based on a medical problem, you have to contact the treating physicians and get letters from each one, or perhaps if there's one who's overseeing all the work in the case, that person needs to be contacted. But medical documentation, since medical issues are the most common form of hardship, the medical documentation is absolutely important, absolutely critical. Evidence of good moral character is the absence of bad acts. Now, you can have affirmative good moral character, where, for example, the person works at their church and helps out with the church and helps with the services for the community. That's a positive aspect of good moral character. And again, the hardship requirements in a 42A are minimal, and a 42B, the whole case is about hardship. In addition to the financial hardship, if there are U.S. citizen or permanent resident children, their school records are important to be able to demonstrate that the child is not a burden to the U.S. government and is doing good things for their own development. The factors that influence the success rate of cancellation and removal cases, immigration history is absolutely critical. If your client has been here, or the client has been here for a long period of time, it's very important that you get their entire immigration history, even for visits previous to the last one, because in that immigration history is where you will be able to see how long they've been in the country, who of their relatives are here, who petitioned for the person, and so that is very, very important. Without the immigration history, you're going to, and you go into immigration court, you're going to be very surprised because your client hasn't told you everything, and it turns out that 15 years ago they were removed and never left, for example. That's a very common issue that comes up. And if the judge orders a final order of removal and you don't leave, there's a warrant for your arrest, and any law enforcement officer anywhere in the U.S. can arrest you based on that warrant. And so immigration history is critical, so you don't miss anything. The criminal record is just as important. A lot of people get involved in criminal matters and they don't understand their immigration significance, and they just poo-poo it. And they go into court and they plead guilty, and then lo and behold, when they want to become a permanent resident, they have this very negative factor that hasn't been dealt with, and it has to be overcome in order to become a permanent resident. So that's very, very important. Like I said, a lot of people don't understand the criminal justice system. They don't want to hire an attorney, and they go ahead and plead guilty. For example, if you are convicted of what is called 2 crimes involving moral turpitude, the most common form of moral turpitude is some sort of theft offense. So if you get arrested for shoplifting, and it's a small amount, say under $100, that's 1 crime involving moral turpitude. If you have another arrest for a similar offense, now you've committed 2 crimes of moral turpitude, and you now are removable, even though each theft was very small. And so then you will be put into removal proceedings, you will be issued an NTA, and in order to prevail, you'd have to prove that either the NTA was wrong or that relief was available. Now, cancellation of removal, 42B, is very, very strictly construed. Like I said, it's very, very hard. So criminal convictions can certainly knock you out. Past fraud or misrepresentation before the U.S. government can knock you out. And not enough hardship evidence can knock you out. But it's not really the amount of the evidence, it's the quality of the evidence. And so if you're just lazy and you say, well, my uncle, he goes to the hospital every 3 weeks, here's all the hospital records, that does not tell the government how actually ill your relative might be. The other thing, a lot of people just go to work and they have normal lives and they don't participate in community activities. And so because they're not involved in their communities, getting hardship evidence is very, very difficult. So you need lots and lots of medical records if you're going to use that for hardship. But, like I said, criminal convictions, fraud or misrepresentation that has been in the past, and lack of evidence will result in a denial of the case. And so these cases have to be prepared very carefully. Judges read every page of it, from my experience. And while they're willing to consider the evidence, it's so hard to get that a typical judge just following the law is not really, it's very difficult to find enough hardship to qualify for 42B. And the judge must be persuaded. You need to draw the judge into the case, get them interested in what's happening to this individual. And that's where lawyer skill comes in. It's the lawyer's job to create that atmosphere in the courtroom, not the respondent. But these cases are heard all the time. Making matters worse, it may take years before you get into a hearing. Things may have changed in your situation where you had a great deal of hardship in the past and now you don't. Say the relative who was deathly ill died. Well, you no longer have any responsibility for that person. And so this all must be borne in mind, and addendums are frequently submitted in cancellation of removal cases because they take so long and so many years that there's more evidence of hardship that can be filed with the case. And you can continue to submit evidence in any cancellation of removal case up until 2 weeks before the actual trial, the individual hearing for the respondent. If you just get the evidence to the court 2 weeks before, they'll accept everything you want to submit. And so it's very important you don't miss deadlines and you make sure that everything is filed on time, because if you're not, then you have to go before the judge and basically tell the judge, hey, I missed this, I'm real sorry, give us some more time. You never ever want to be in that kind of situation with a judge if you can avoid it. First, disqualify for cancellation or removal is done by the judge, and the most common reasons are crimes, fraud and misrepresentation, and not enough evidence. Like they'll say, well, yeah, there's extreme hardship, but it's not extreme and unusual hardship. Extreme and unusual hardship is the highest standard that there is, and the evidence necessary to sustain that is extreme. I've had numerous cases where I've been successful at 42B, and they're mainly won based on the evidence of the extreme and unusual hardship. It's not enough for example, for a physician's letter to say that Mrs. Jones is in the hospital and she's suffering from pneumonia. That's not enough, because pneumonia is not a life-threatening condition. It, generally speaking, doesn't result. It results in a couple of weeks in the hospital at the most. However, if you're elderly and you have other underlying medical conditions, this needs to be brought up, because the assumption will be that this can be solved in a few weeks. But if the pneumonia is what's going to trigger a hospitalization and may result in the death of the individual, that's exactly what you want to do. And I've had several cases like that where the evidence did show a qualifying relative, and the hardship has to be very, very extreme. But in the cases that I've done, it's usually in a family situation. It's not employment-based. Immigration is not really going to help with all this stuff. But if it's family-based, that's a different story. So when I argue cancellation of removal cases, 42B cases, usually the application form is several hundred pages long by the time it's filed with the court. In addition, expert witnesses may be necessary to bring to the immigration court. I've done that many times in cancellation cases because I want the judge to be able to examine the expert, so the judge can decide for himself or herself whether this evidence is credible or not. Just give the judge a letter. The judge is no doctor. The judge has no idea about the significance of the letter unless it's explained very clearly. Most doctors don't want to take the time to explain it very clearly. So oftentimes there's the doctor's letter and then another document about what the terms are that the doctor's using, because you want the judge to be able to see the full hardship just like the doctor does. And so in my cases where I've had that opportunity to bring expert witnesses, that changes the whole complexion of the case. Because unless this judge is going to find the expert witness to not be credible, the judge will accept the testimony of the expert, and I've done that in numerous cases. Numbers of children that the person has, that's a really critical factor too. Who's going to take care of the children who were born in the US if the person is sent out of the country? So that's another factor that I usually use when I do these cases in court, to show that this whole family is just going to be stranded, and US citizens cannot be forced to leave the country. And so that being the case, it creates a very difficult situation when all of the relatives are US citizens, and so with the relatives all being U.S. citizens, those are very, very important hardship factors. Usually the person being deported is the rock of the family, and once that person's gone, the family may fall apart, because not everybody's going to go and live in a third world country where their life might be in danger. And that's another argument that I frequently make in cancellation of cases, and it has been successful on several different occasions where I've been involved in those cases.